I'm facing corruption charges. They sent her to my case so they can release or smoothen the pathway for the husband and the son. They are facing, it doesn't matter in the office. In a court setting, that's what happens. They are very, very corrupt. There is a breach of judicial oath. They have violated the judicial oath. They have shown bias according to Supreme Court. They are biased against me. Supreme Court said so. And that is why what is happening in the judgments and rulings concerning me has been happening. Disobedience to superior court orders. Supreme Court said you are biased.
The law that I have contravened, yes. You cannot ask me to enter a defense for a law that does not exist. And particularly, the law that the Supreme Court itself has declared non-existent. So what will I be defending? We're in a country where...
Nnamdi Kanu's hearing, court adjourns case, gives final chance to enter defense. Abuja, November 5, 2025. The Federal High Court in Abuja on Wednesday adjourned the trial of Nnamdi Kanu, leader of the indigenous people of Biafra, Ipob, giving him a final opportunity to open his defense in the terrorism charges brought against him by the federal government. Justice James Omotosho, who presided over the case, ruled that Kanu must present his defense at the next sitting or risk losing the right to do so. The judge stated that the court would not entertain further delays, stressing that the adjournment was being granted in the interest of fairness. During today's proceedings, Kanu, who appeared in court without his senior advocates, told the court that he would not open his defense, insisting there was no valid charge against him. He argued that the law under which he is being tried had been repealed and, therefore, could not sustain the allegations leveled by the prosecution. The prosecution counsel, Adegboyega Awomolo, SAN, urged the court to foreclose Kanu's right to defense, noting that he had repeatedly refused to proceed despite several opportunities granted to him. Awomolo contended that Kanu's stance was a deliberate attempt to stall the trial. In his ruling, Justice Omotosho declined to foreclose the defense but warned that the court would not grant any further adjournments beyond the next sitting. He ordered that the Department of State Services, DSS, must allow Kanu access to his legal consultants to enable him to prepare adequately for his defense. The matter was subsequently adjourned to November 7, 2025, for continuation of trial and possible opening of defense. Today's hearing marks another turning point in the long-running case that has spanned years of legal battles, jurisdictional challenges, and political tension surrounding the agitation for Biafra. The outcome of the next hearing is expected to determine whether the case will proceed to judgment or remain stalled over procedural disputes.
We have reached a turning point in a high-stakes trial. The trial of Nnamdi Kanu, the leader of indigenous people of Biafra, Ipob, has entered a critical phase. On 5th November 2025, the Federal High Court of Nigeria in Abuja gave him a final ultimatum to enter his defense by 7th November or risk having his case closed. This moment marks not just a procedural juncture in one trial, but a flashpoint in Nigeria's broader political, legal, and security struggles. This article explores the recent proceedings, the arguments in play, expectations for the outcome, and the ripple effect across Nigeria's political landscape. Let me bring you up to speed with what just happened in the recent proceedings about his case. The first thing to consider is the prosecution's closure and Kanu's refusal to defense. The prosecution concluded its case against Kanu and his co-accused earlier in the year, presenting 8 witnesses and evidence. But the major shift came when the court rejected Kanu's no-case submission and held that he had a case to answer. Since that ruling, Kanu, who has often represented himself, has repeatedly declined to open his defense. He maintains that the charges in which he is being tried for are invalid. They are trying from invalid cases, arguing that the law under which he is charged was repealed and therefore the proceedings should collapse. The second outcome of the proceedings is the court's ultimatum. On November 4th, the court warned Kanu that if he did not open his defense by 5th November, his right to defense could be deemed waived. Consequently, on 5th November, the judge, James Omotosho, gave Kanu until 7th November to open his defense or have his case foreclosed. The judge stated in his own words, now I know that he is an economist and not a lawyer. I will give the last opportunity to defendant to put in his defense. Failure, which he will be deemed closed. Those were his words. That is James Omotosho. Another point of interest is Kanu's position and legal strategy. Kanu insists that his charges are null and void. He argues that the law, often cited as the Terrorism Prevention and Prohibition Act of 2022, under which he is charged, was repealed. He claims that the trial is politicized and object to entering a defense because he believes there is no valid charge or counts cognizable within the corpus juris of the Federal Republic of Nigeria. His legal team, or rather his consultants, as they are now, and how the courts pointedly call them now, is also under scrutiny. The judge admonished his ex-lawyers turned consultants for media commentary and for straying from professional ethics.
Concentrating on the objections raised to the jurisdiction of the court. On that note, the court adjourned for further hearing to 7th of November, when the court expects that he will enter his full defense. Well, having said that, I know a lot of people have raised questions and eyebrows about the propriety of Mazen Nnamdi Kanu representing himself. It is his decision to make. He has the right under the Constitution to defend himself, and this case being politically charged, I think the idea or the notion that this is a normal criminal case has to be dispensed with. This is a normal criminal case at all. If you want to understand the complexity of this case and the true political dimensions to it, you think of the case of Nelson Mandela, Martin Luther King, or Bafemi Awolowo, Mahatma Gandhi. These cases were all politically tinged cases masquerading as criminal prosecutions. And these great men I mentioned, at some point in their struggle, at some point in their travail imposed on them by the state, they took the podium and defended themselves. So a politically charged case often comes with some unusual dimensions like this. So because, why? The reason is simple. Lawyers are restricted to very narrow wiggle room when they are doing a case. And that narrow wiggle room can be inimical, can be prejudicial to the interest of the client. When the case has a political dimension to it, that thing needs to, the defendant himself will make the best defense of his case at that very point in time. That does not obviate the fact that the presence of a lawyer in a case is always better. But in certain circumstances, there are exceptions, and the exception is, this one is one of the major exceptions. Thank you. Thank you very much. Thank you very much. Thank you. Thank you.
But what are the stakes of not defending himself? If Kanu fails to open his defense, the court could proceed to judgment based solely on the prosecution's case. In legal effect, that could mean that, or just mean a judgment for conviction if the case is found proved, or a judgment of acquittal if the court finds that the prosecution failed to discharge its burden. But the procedural risk is high. Kanu's silence now might severely limit his options and raise questions about fairness, due process, and the political dimension of his prosecution. So, what's at stake? What are the legal, political, and social dimensions? Let us look at the legal implications. The outcome of this trial is not just about one man. No. It carries implications for how terrorism and separatist-related cases will be handled in Nigeria. If the court rules that a charge under a repealed law is invalid, that could open a Pandora's box of similar charges. Conversely, if the court moves ahead and convicts, it may set a strong precedent for prosecuting separatist leaders. What about the political and national security impact? Kanu's trial sits at the nexus of national security, given Ipob's proscribed status, ethnic and regional agitation, especially in the southeastern part of Nigeria, and the Nigerian state response to secessionist demands. A conviction might dampen Ipob's momentum, but it could also inflame tensions. An acquittal or collapse of the case may be construed as a victory for the separatist cause. Let us look at the social and human rights ramifications also. Human rights groups have long flagged concerns about Kanu's arrest, extradition, detention, and trial. Whatever this verdict, questions about the fairness of the process, equal access to justice, and potential political interference will remain. It will remain front and center, definitely. What are the expectations going forward? The scenarios. The first scenario is that Kanu enters defense and case proceeds. That's the first scenario. If Kanu opens his defense by 7th November, the court will hear his submissions. The defense might argue the invalidity of the charges, ask for dismissal, or present evidence or witnesses to counter the prosecution. We might then expect a judgment date set shortly thereafter, possibly maybe in early 2026. And then the second scenario is a situation where Kanu does not enter defense. That is the case for close. Should he fail to act, the court could deem the defense closed and move to judgment solely on the prosecution's evidence. That will increase the probability of a quicker outcome. It could also raise complaints about fairness, especially from his supporters. The third scenario is that the case collapses due to legal defects. If Kanu successfully persuades the court that the charge is incompetent, then the trial may be dismissed. He could be released depending on remand status. However, that outcome might energize Ipob and similar groups and raise major questions about the corrections needed in anti-terror law prosecutions. But why is this case or this story going viral? What are the ingredients in this case? There are high emotional stakes. The question of self-determination, regional identity, and state response resonate. A case of legal drama, the final chance ultimatum given by the judge, creates tension and narrative arc. The political intrigues are there. The interplay between court, state, separatist movements, and public sensation matters a lot. The public interest in Nigeria and abroad, audiences are watching how such a landmark case unfolds. in all of this, what our expectation, what we look up to? Will Kanu open his defense by November 7th? This is the immediate cliffhanger. Any ruling on the validity of the charge if the court addresses Kanu's argument that the law is repealed. The consideration of timeline for judgment. How quickly the court moves after closing defense. The public and regional reaction, especially in the southeast, where Ipob has strong following. The implications beyond Kanu. How this trial will influence other secessionists, terrorism, or politically sensitive cases. In short, this moment may well be a turning point, not just for Kanu or Nnamdi Kanu, but for how Nigeria navigates law, dissent, and national unity moving forward. Thank you.